Now, the hearsay issue was very, very important, but the police advisors, let's call them, in Kansas would not explain that to the father in detail. They simply said, we're not leasing anything without a subpoena. And when he was upset about that, when I explained what was going on, I said, you don't have any idea how much they're helping you. They're doing everything they can. And this was like 2 o'clock Friday afternoon, and when he noticed his child was missing and it was someplace, they thought maybe it was at school, and he verified it was there, and he was happy that it was safe. But he then started proceedings as to, I want to see my child. So he calls me up and he says, they won't, I can't see my child because the visitation is not specific in the orders. It says, pending a visitation schedule. He says, well, we're all messed up, aren't we? And I go, no. You go back to the police, and their job is to provide what we'd call supervised visitation. And that's what they're trying to get him to do. Establish your supervised visitation so we can maintain the peace. And boy, did things change then. Now the mother totally left the area and left somebody behind. First she said to the police, I never pushed my kid down the stairs. I wasn't even home that night.
Yeah, there you go. That's a confession.
My husband did that. The new husband she married. He did that. And she's been a habit forming of doing this. I feel bad for this poor guy. I really do. Because then what she did on Saturday when the police said, okay, fine, we're going to have a supervised visitation. When they went to the home, she was gone with the kids. Who did she leave behind?
The criminal.
The criminal.
You push the kid?
She left him behind and told him, just relax. Well, his way of relaxing is to take a few. So here's the supervisor with a uniform and armed going, oh my. And the criminal then said to the father, well, you can visit with me. So you can understand with the proper documentation and everything that we need to follow through with these things, you're in a strange land. I can even be in Ohio, you're in a strange land. But he had to leave, of course, without seeing his children because she just hid. She just took off, took them both, and left the husband behind to fend off.
Talk about continuing amounts of dishonor.
And he gave the excuse, well, and it was documented that the mother had a dinner engagement to take the children to. That's the best he could come up with. Well, if it's a family, why aren't they all taking the children to a dinner engagement?
A dinner engagement at McDonald's.
Yeah, it's at the mall. We're going to be at the mall all day. And so I felt sorry for the father because it was a long trip, a day trip to Kansas and a day trip back. Within the modified agreement, it is the mother to pay for all charges of visitation.
So he'll bill her?
So he'll have to invoice her for this. And he'll invoice it through the proper procedure and make sure it becomes a record of the court. And she'll fail to pay invoice, and he'll get a letter of dishonor on this, and he'll just go on down the line and then make that an element so that can be brought in also. Yes, she is delinquent in support. It's getting up in the double digits, and she doesn't care because she thinks she's in Kansas. I'm not sure about what Kansas does, but they're giggling. She has just recently became capable of supporting the 2 children she has. They've been following her, and they said now she is making money in excess of the minimum to support 2 children. So they've been following this episode, and it's all pending. But we're hoping now with the additional dishonor and with the letters from that state and the fact that finally we have the county, interested in with an intake person as to what's going on in the best interest of the children. And it will become a custody issue here. It wasn't a custody issue in Kansas. and that's a tough position. If you put yourself in that position, that father, that hysterical situation, where the child, and the police have a record, the child insists on not going back with the mother. Well, they can't. They have to put the child back with the mother. They had no other way of doing it. The mother got in there at 9 o'clock in the morning. Hey, I want my baby back, and they put the baby in school, and they said they had nothing to do because the child did not have any broken bones nor cuts, wasn't bleeding. It did have bruises, and it did testify that it was thrown down the stairs by the father. By the criminal father. But that wasn't adequate to create any kind of a, they needed more. They needed to see more damage.
But you're absolutely right. The police did him a favor because rather than just give the reports, if it goes through a summons, it will be executed by the court and by the officers of the court, which means when it comes back into Ohio, it is a perfect third-party record rather than just pure hearsay.
That's right.
Okay.
And he's learning fast.
There you go.
First of all, he learned not to argue. So when they said summon, you have to subpoena all this, he said, thank you. Mm-hmm. He said, I remember saying thank you. They go, okay. Is there an attorney around that I can use to obtain this? And the lady said, I think you're probably more comfortable back in Ohio.
Mm-hmm.
Because that's where the power is going to be for the subpoena, the information. Because it came from one of their attorneys. It could be considered hearsay again because it didn't come through the agency of Ohio, through one of the agencies, protective agencies. So they are working very hard, and I know they talk in code. I know it's not easy to understand. Even I have a hard time, and I keep calling Jack, what's this? And Jack says, could be, and off we would go on it. But it is the essence of the process is you have the private and the public side. He's running around. He had his legal agreements. And when they looked at those legal agreements, they said they are not enough for us to do anything. And then they had a judge come out and talk to him. And the judge said, I don't split children up. I don't split siblings. That's it. Unless I have an order to do so. So he's going to protect his two children. He's going to protect them. They're going to stay together in his state. They're going to be protected. He receives an order from Ohio. You're gone. That's it.
There you go.
So it does work, and he has done nothing. Now, he did have an attorney at one time. The fellow was, we really didn't know what to do with the attorneys. And we're learning better now. We're getting closer to how to handle these people. And so since we have more knowledge, we're less suspicious. And I think we're going to keep working on that suspicion situation. That doesn't mean they're not going to be always advantageous. All right. I think they're always going to be advantageous in their behavior, looking for the best for them. But I think we'll be able to manage what their procedures are and how to implement their procedures and get them to implement the procedures for us. I think that's very important. And I'm looking forward to maybe putting some of that in outline. I know a lot of people are in the middle of that at the present time, and they got some test cases out there, taking an attorney that has motioned themselves off a case. And Jack, I was just going to share this quickly with you. I had an idea about going to actually an attorney as counsel and coming in with the letter rogatory in which you instruct the attorney to motion the court to be relieved of the public side. Actually go in there and say, I'll motion the court to. I mean, we have to work because there's a funny process in here.
That's probably too much truth for the court in a document.
Yes.
It's going to have to be a little bit
colorable. We have to color that out a little bit.
Yes.
But there seems to be, when I work with public assigned attorneys in cases, they work in that prospect. They work on the fact that they know they're going to be off on the public side and they hang in there on the private side. And matter of fact, they even do it without submitting a real motion. They'll simply say to their client, I can't go into that court like that. And they don't. They go in on the other side, but because they were assigned publicly. And they work with the prosecutor. They then submit all the information they had to the other officer of the court on the public side. And they act as a mediator. And but I haven't been able to nail that down to a procedure. I'm hoping that in the very near future we will be able to, because I think that would really help, especially in a situation we have with this father. He's not going in the direction of an attorney right now, because he's working with the attorneys from the county and agencies. And I said, I think that's where the real power will be in this, is to bring those people forward and work through those individuals who will come in and plead the petitions of the father.
Yes, I believe if he approaches the child welfare agency in Ohio with the subpoenaed evidence of the treatment of the child in Kansas, that's going to be his most powerful influence. And
they're doing their work, and I'll be overviewing just a little bit of their work. This couple is a wonderful couple. It's interesting because he'll come to the class once in a while, but he has a hard time because he has other obligations. And I'd say that there are other obligations because they're extremely Christian people. They're very, very dedicated. And so this gives, unfortunately, they have a lot of things going on to help other people. And it's hard for them to break from that. So we're providing as much tutoring as possible, but they're very receptive. And I think it's working very well. And that's sort of like people on the tape listening. I know I'm going on a little bit, but you can become more than just simply going out and seeing how you can, get out of doing something that you've been drafted to do. And it's much more powerful than that. And so I think that they receive a lot of reward from what they are presently doing themselves. That's what's giving them some guidance and some courage.
Super. Well, thank you, Lee. Donna, your position was is if we get an administrative judgment and we take it back to a public proceeding, what do we do with it? Well, we have to petition the public proceeding through their agencies and stuff as a second witness to help resolve this. Are you going to get them to execute by common law on it? The answer is no. They will execute based on dishonors from the other party if they fail to live up with the agreement. When they fall into a dishonor to the agreement, when you raise the evidence of that dishonor through third-party witnesses. Does that help, at least in some respect, show you where it's coming?
I was worried that my 3 previous administrative procedures haven't been bad enough to go to either court or to the zoning hearing.
Well, if they don't come back...
We've only argued grandfathering. That's the only thing we've covered. And there's other issues.
Yeah, but that's sufficient right now. There's another party in the room here in which there was a statute violation brought against them just on an apartment building issue and parking lots and stuff. And the fact is this apartment building has been there since before Ohio. And the problem with the paved parking lot, that was a statute or an ordinance in this community in 1959. And in reality, what they're doing in this particular case, they're not interested in charging anybody under the statute. We absolutely believe, just like Peter raised at the beginning, that in Lakewood here, or Bob raised it, in Lakewood, it's a notorious suburb of Ohio, Cleveland here, which is using its eminent domain authority to try to just obliterate a whole area of that town in order to bring in a brand new commercial development that will bring millions of dollars of new tax revenues into the community. And so the idea is, can we just get rid of homes, businesses, and everybody that have been in buildings that are 15, 20, 30 years old by eminent domain just to put up a multi-$100 million development that will raise tax revenues for this community that will help that community meet its commercial obligations. And so there's all kinds of political arguments going on. Of course, everybody's fight, fight, fight. And that just brings warfare, which brings the ability for the people making the decisions to do whatever they want because everybody's in a dishonor. Okay? Well, in this case with this person in the room with the apartment building, it's in a part of a town in which there's rumors that a very expensive development is going to go in several blocks away from this particular facility. And it becomes obvious that what the community, the politicians are doing is they are literally trying to stimulate charges and dishonors from parties in the community to be able to lower the property values of the existing older facilities there so that commercially the people that own these facilities can't make a go of it anymore, so that the property values drop so that when they go for eminent domain, they'll pick up the property for an arm and for a song and then resell it to other developers for a huge capital gain. So that's what they're trying to do here, but I mean, you can't go into court and say you're trying to steal my property because there's obviously no evidence of that or anything else. There's just a pattern, very subtly, they're using the powers of enforcement in the city to cause problems in this areas of the community to see who will or who will not go into dishonors so that they can issue either criminal or civil court settlements, which is going to subtly affect property values over the next couple of years to help out the developers on the areas located a couple blocks away. So you got to watch what you're doing.
I've heard you say that the administrative procedure only holds for about 90 days. How many days do we have after the notary protest to either go in and request the court for relief or to go back to zoning and having a public hearing?
Well, understand this. It'll only hold for 90 days if there is some form of actual draft that's against you. Now, in your particular case, you have basically established in the background your thinking as to why your property and the status quo is immune from any of their actions. Nobody in that community has brought a civil or a criminal action against you to change anything.
I know, but they keep coming. We have another letter inviting us to license, and I would expect myself, even though I've started the letter procedures, that possibly October 1st I will get a violation notice. I don't know whether they'll...
Don't anticipate anything. If you expect it, you'll do something to bring it on by a dishonor. Just go in there with the acceptance on the conditional proof of claim that there's anything that takes you out of the condition of the grandfather clause that changes anything bringing you under the scope and purview of the legislation. Let them respond. Just because they write you a million times doesn't mean that there is anything that initiated a 90-day do or die thing. The only thing that initiates the 90 days is if they bring an actual charge or something against you and you try to do a settlement and it's not resolved in that amount of time for some reason. They have no charges, so there's no 90 days that has started for anything at all. Okay? Pete?
Lee mentioned something that brought a memory back to me. He talked about the child being thrown down the stairs and there was no bruises, cuts, broken bones, anything like that to show that he'd been thrown down the stairs and therefore they couldn't do anything. My daughter was attacked a number of years ago by an ex-boyfriend of hers. She used to waitress on the Nautica boat and they'd get back at 1 or 2 in the morning and it's a bad area down there. So Saturday morning we went into the Cuyahoga County, Cleveland prosecutor's office, and we were trying to see what could be done to get a restraining order to keep this guy away from her. We sat there for 2 hours and talked to an assistant prosecuting attorney. 2 hours on Saturday morning. And I finally backed him up in the corner, And I actually got his mouth to say, Miss Stroth, there is nothing we can do to help you. If he kills you, then we can help you. And I think that is a telling thing. Basically, unless they kill you, there's nothing they can do to help you. You're on
what
your own.
He's saying is we're admiralty, but our actions are founded on common law. And until there is an actual damage in common law, even our process doesn't kick in. We can yell, we can scream, we can spout, we can act like we can do everything in the world, but our foundation is based on the common law. Until there's actually a damage, there's nothing we can firmly do. Yes, Joe?
Yes, this is Joe. Earlier, when you were talking about the system waiting to see who was going to dishonor who first, and when you talk about Lakewood trying to get some property to build a $1 million complex, whatever, aren't those things in itself a dishonor from the onset? And anything that follows after that is null and void?
What things from whom?
Well, in the case of the child, the court is dishonoring both of the parents. They're waiting, they're delaying the case instead of getting a resolution. In the case of Lakewood, they're expecting to get the property cheaper than what that value would be to the personal homeowner should that that complex arise. People would say, oh, you want to build a complex? Okay, my house is now worth $500,000 instead of the $50,000 you want to give me now. Isn't that a dishonor?
Okay, actually Lakewood has legal title all that property irregardless. And whether the trustee wants to use it for a high purpose of a multi-million-dollar development, or whether they want to use it for a low purpose of allowing the resident tenants there, is not really the issue. They've got legal title, and the trustee can decide legally what's going on. From a practical point of view, the trustees are backed up by the public support. And so the trustees ordinarily probably do not want to get beyond at least the majority of the public support. Otherwise, it becomes pretty nasty, and the true nature of who rules in the democracy then becomes apparent, which might not politically be a good fact to have brought to the public generally. But if you notice what's happening in Lakewood, the arguments from the public sector are the future of our community needs this fancy commercial development. So they're speaking from a public commercial point of view. The people that are going to be thrown out of their existing homes and businesses are arguing the private side right to the enjoyment of what they erroneously believe they have total control over, which they don't have total control over. However, all of those businesses and all of those residents do have rights to 100% of the equitable value of what they've got in their property, be it commercial or be it private residential. So now the problem on the part of the city is that if we could lower the equitable value of these properties without it appearing to have been our fault that the property values were lowered, then we could pay off the equity that we would owe the displaced residents and business, with less equity, obviously, than if we had to pay them off at the top dollar. So when the community goes out to try to put in a multi-million-dollar development like Lakewood's doing, obviously it makes more sense purely commercially in terms of future profits and intended investments if they could buy the current assets at a low value, create high value assets, and market the high value assets commercially so that there's more profits. more returns for the developers. So there's subtle ways that the cities or the states or the feds can go about lowering the property values before the appraisals take place to decide and peg on the value of the property. Now, Joe, you said, why don't the owners just say, good, you can buy my house for $1 million, even though the market would pay you $50,000 today or whatever. The problem is that neither the buyer nor the seller, in an action in which the government is going to use their methods of property confiscation, are going to unilaterally set the price because they're both involved. They will go to a third party to establish the valuation of the property. And if the owner of the property says, I've got $1 million property, and 3 appraisers say, no, you got a $250,000 property, then they will get a court order, most likely, that seizes the property pending an agreement to the valuation of the property. And it will go into some kind of administrative procedure which the court will mandate whatever comes out of that proceedings is going to be the value that the previous owner is going to have to accept. And I guarantee you it ain't going to be $1 million if the marketable value is $250,000 by a bunch of appraisers. So you can't just say, yeah, fine, you can take my property for $1 zillion because you're not the legal title holder to that property. If you were the legal title holder in addition to the equitable title holder, then it's assumed and presumed that they're really going to have to do something by way of eminent domain in order to buy you off. And if you had legal title, I don't think the public in its bankrupted condition would ever be able to buy you out of your legal title because they'd never have the assets to convey to you the proper exchange to get the title to that property and give you another property. However, they're just dealing with equities. You're not dealing with legal titles. Lee?
I do not mean to distract from what we are just saying, but something I have just reflected to. And when Caleb's eyes were open and ears were listening, he said about the notary. And it just occurred to me that the intake person in the county, when asked, are you an attorney? The woman said, no. Are you a notary? Yes. Here's the notary taking the testimony of the people to go before the officer of the court.
And there you go, second witness again.
And that, I mean, you know, all of a sudden we start to see this isn't new. We're not inventing it. We're not creating it. It's there. It's just that we just haven't been able to see it. And so with that in mind and what Jack just went through, the great explanation of what the notary's power was of taking that testimony, now I know how to address that intake person in the proper form so as not to cause that intake person any distress, but to just allow them to do their job without any insinuations that they are stonewalling or not cooperating. And that's what happens with a lot of these intake people. So we're going to go in that direction. And so if you learn a few things on a Monday night and Monday night tapes, I think then you'll be able to watch these people in these agencies and see and ask, who are you? Are you an attorney or are you the notary? And you'll find that if they are the notary, then that's how you have to address them, as to becoming the witness and of the testimony that you're going to bring, and have your testimony ready. Not just fire off a bunch of insults, but have affidavits, have your stuff in writing, what you need to present.
Yeah, and in essence, what's happening to this father when the police said, subpoena us for the evidence, there it's going to come under seal, and that's the evidence that's going to go to that intake officer on behalf of the father. He's not going to come back to to child welfare in Ohio and say, did you hear the heinous thing that my ex-wife and her new husband is doing to the kid? It's going to come through the public channels.
That's right. That's right. And it's that intake person, that notary, will be placing that testimony, and then the subpoenas for the documentation will be coming forward.
Absolutely.
It'll come through that avenue. And it's great that we had this discovery, because this allows me to assist in the tutoring as to, now, how do I talk to this intake person? Well, other than good morning, this is what we need to present so that they can do their job.
Yeah, and remember, the intake person is just an administrative agent looking for what are you bringing to me that you want the public to see in regard to this matter. And in reality, when you look at the signature and the seal of the public notary on those documents, you'll think of that in terms of getting a record that now is visible to the public, instead of thinking, oh, I got this certificate of protest here, let's go out and nail these people for being such dishonorable people. No, you're looking at the wrong side of the issue when you're thinking of using the notary to bring charges against your brother, rather than using the notary as the administrative agent, which is going to reflect the record that the public is going to see. If the other party has been dishonorable, it's the fact that he didn't show up to make the record. And that doesn't give you a cause of action against him. It gives the public opportunity to say, but you had your opportunity and you never showed up. Let the public get on his case. It's not for you.
That's right. That's where all those certificates of dishonor, I have found to be powerful when you put your last letter of advice out that says, would it be all right with you, bad person, if I attach your certificates of dishonor to my petition for an order of the court to dismiss this action that you have drafted against me?
So you're
I'm
submitting
giving you
to the public to
yes,
deal with.
That's right. And you
with
have
his permission.
With your permission. And you have 7 days to respond. If you fail to do so, you will receive an automatic 3-day extension under a notice of dishonor. And when they get that, they have one last shot. And then you can take that and attach those certificates of dishonor to your petition, and then you serve them a copy of that petition. And you're off and running. And that's the procedure that I have found. You're not using those certificates of dishonor as a charge, as a threatening charge. You're using them as a finding of fact. And that you can bring in as evidence that is not hearsay. And that's what the power is. And from that point on, it's a matter of allowing them to come into that court under your petition. And when you're petitioning the court for that hearing, let them come in under show cause why they should not follow the order of the court to cease, because they've already agreed to by their non-appearance. And you're coming in there with that, and then let them testify themselves into a hole.
There you go. Great. Yes, Joe.
Yeah, one quickie back to what you're saying about Lakewood. I think you said the people who own the houses don't have, I think you said, equitable title.
They don't have legal title.
Legal title? Okay, then that's why they can't argue their case or have any.
Oh, they can and do argue their case.
All right. But can't win the case.
They don't have control over their property.
Right. Okay. The fact that the Lakewood isn't telling the people that, isn't that a dishonor? Not giving
Why
them all
should
this
Lakewood tell them a condition which has existed universally for a long time under the presumption if a person gave away control of his property, we assume and presume he understands what he was doing.
If they understand it, but I'm under the impression they don't know that they gave that away.
So what's the point? If a person's ignorant, does he have any rights? How does an ignorant person have rights if he doesn't know he's got them?
An ignorant person cannot be held liable for a contract if he doesn't know all the parameters of that, right?
That's under the common law, not under the admiralty.
Well, I don't think people know about admiralty, and to me that seems like a dishonor, no?
So they're ignorant. So they have no rights. It's an oxymoron. How could an ignorant person have rights that he doesn't know about? Because to have rights, you have to act pursuant to those rights. And if you don't even know you have them, how can you act on them? And if you can't act on them, you're incompetent. And if you're incompetent, then somebody must be appointed over you because of your incompetence. And guess what? That's safe. They're appointed over you because everybody's incompetent. Don't believe me? Just get a public school education.
Right. But I don't think the people know what you just said.
Why, absolutely true. Otherwise they wouldn't be ignorant. Now they'd probably have rights. There you go. My people perish for lack of knowledge. Okay, couple interesting things. We've been talking about attorneys. I had a tutor with a guy this week, and this guy's in a criminal case, but he happens to be out of jail, thank goodness. He's been in jail, didn't like it. So he got out of jail, and he's got a couple of really nice felonies hanging over his head. And he's getting a little bit worried, as well he should be. I'll just call him Larry, okay? He's not from this state. And Larry used to have a public defender in his case, but long around May of this year, they had a little hearing, and the judge in the case really perceived that Larry wasn't treating his attorney very nicely. And Larry said, I don't want no stinking attorney. These people are whatever and whatever. And so the judge basically discharged the public defender. Well, I've been talking to Larry, and I said, why did you have him discharged? Why didn't you want him? And he says, oh, the attorney grants jurisdiction. I go, whoever the hell told you that? And he said, well, it's public knowledge. The patriots all believe that if you've got an attorney, he grants the court jurisdiction in your case. You can't have an attorney. And I said, gee, maybe I was born backwards then. I thought it was the other way around. Let's see if I get this straight. Who's the defendant in the case? He goes, oh, that's the straw man. I said, yeah, we're both in agreement there. Who created the straw man? Well, it's the state. Okay, we're in agreement there. The straw man was created by the state. Can the state charge their creation in their court anytime they want? Absolutely. Okay. So, now, let me get this straight. The living man wasn't charged as the defendant. The straw man was charged as the defendant. Is that correct? He says, that's right. I said, so why are you in there, pro se, defending their creation? It sounds to me like if you walk into their court and defend their creation in their foreign court, you just volunteered into jurisdiction in their court to defend their creation. Now, that's a grant of jurisdiction. I said, wouldn't it be much better if you didn't have anything to do with defending their creation, but you had a counselor and you had the counselor just give input through the counselor to this foreign court involving their action against their creation, which are all fictions, and you just telling the counselor when you go into that court, remember, I'm not the creation of the state. I'm not the fiction. I'm just here as a third party, aggrieved party, and I've agreed to honor you guys by paying the bill for whatever it is that you find your creation liable for. I'll be so nice, I'll pay his bill out of the goodness of my heart. But I am not the creation of the state. I'm not defending him. I don't want anything to do with him. That's for your foreign court, your creations, and your officers. Now, how does having an attorney representing the defendant in the foreign court grant jurisdiction over you, the living person, that's not involved in the defense? And he goes, well, I can kind of see that, I guess. And I said, it's just backwards from what you people are arguing. So I said, now, if I get this straight, the defendant doesn't have an attorney anymore except you, right? I guess so. And I said, Well, you do what you want, brother, but if I were you, I would do the letter rogatories and ask the officers of the court to tell the court that you, as the third party aggrieved party, want settlement and closure. You agree with all the facts and everything, and please just handle this. Let me know what the bill is, and I'll go ahead and take care of it by way of the exemption. He says, "Oh, you want me to file that in the court?" I said, "No, only officers of the court file things in the court." He said, "Duh, maybe that's why I was in contempt before when I put stuff in the court and they told me not to." Duh! How many times do they have to tell you right and you have to start believing them before you're not getting in trouble? So he said, "Okay," he said, "boy, I don't know, but these felonies look really bad, man. I got to do something." So he drew up his letter rogatory and all his requests and the bill of exchange and all this kind of stuff. And he sent everything to the public defender, the one that used to be on the case. And he sent it by certified mail. And then he put copies of everything out to the prosecutor, the judge, and the clerk, copies of his private letter rogatory, and sent those out by certified mail, and he mailed everything at the same time. And it went out, and he's been having some tutors with me weekly, and he goes, "Oh man, I put that out there, I bet they're going to come and arrest me and throw my ass in jail." I said, "Why should they throw your ass in jail? You put a letter of advice to an attorney who's an officer of the court to do honorable things. You're in dishonor of no one. You're not trespassing upon a foreign court. You're asking their agents to do it. Why are you worried about getting arrested?" "Oh man, they arrest me for everything." So he calls me up last week and he says, "Well, the good news is they haven't arrested me yet." And I said, "Well, I didn't really expect it. You're in honor. What's going on?" "Oh man," he said, "the mailman came today and he called out from the curb. He said, 'Hey man, I got this thing for you to sign.'" And he goes, "Oh man, well, who's sending me stuff now that I've got to sign?" And I was going to hide in the house, but the mailman saw me, so I walked out there and I said, "What have you got?" And the mailman said to me, he said, "Well, sir, you sent this package, certified mail, to this public defender attorney here a week ago. And he's refused delivery. And it's coming back to you. But since it's certified, I need your signature that you got it back." "Oh man, I don't know if I should take that letter or not. If I don't sign for it, what are you going to do with that letter?" "Well, if you don't sign for your own letter to take it back, we're going to take it to the post office." "Well, what's going to happen to it there?" "It's going to sit at the post office for 10 days, and if you change your mind, come on down and get it." "Well, what happens after 10 days?" "Well, it's going to go to the dead letter office." And so Larry says to me, "Oh man," he said, "what do you think I ought to do? I don't want to sign for that thing back and be in a contract with them." And I'm going, too late. You're already in a contract with them. You're in a contract and everything that happens. That's the way the world is. The only question is, are you dishonored in the contract agreement, or are you in a state of honor? "Well, what do you think I ought to do with that letter? If I take it back, I'm admitting that he never got it." I said, "Yeah, but if you take it back, it's evidence he dishonored you and never got it." "Oh, well then you're telling me I ought to go get it and sign for it?" I said, "Well, let's think about this for a minute." Okay? So we're kicking this around and it's just getting better all the time. I said, "Now, look," I said, "did the court tell you that they granted the public defender's motion to be dismissed off the case?" He says, "Yeah, I think they kind of do that, but I can't remember. That was months ago." I said, "Well, okay, let's assume the court granted the motion and the public defender is no longer the attorney for the defendant in the case. Okay? Has there been any other attorney or counsel appointed for the defendant? No, I don't think so. I said, good, excellent. What you do is you go down and sign for it and get it back. But don't open it. Just get it back and don't open it. Proof that it came back in its pristine shape. And that the attorney didn't get it, didn't open it, and dishonored it. Now I said, you know, nothing happens in a vacuum. Everything's interrelated. And I said to Larry, I said, when did you mail all the other letters that you also mailed to the public pretender? Well, they all went out at the same time. I said, let me get this straight. The clerk, the judge, and the prosecutor all got their letter mailed at the same time you mailed the package with the originals to the public defender. Is that correct? Yep. I said, I'll bet you $1 one of the 3 other parties got their package first, and they called up the attorney.